I'd like to welcome Deann up here. Thank you.
Thank you, Maureen. I think it's fair to say that I'm also a longtime member of the Hermosa Beach Chamber of Commerce who is hosting this wonderful event. Thank you to Maureen and to the Hermosa Beach Chamber of Commerce for putting this on for us today. When I founded South Bay Business Lawyers in 2007, I've been living here for over 20 years, but really wanted to become more immersed in our community, so we are a member of the longtime member of Hermosa Beach Chamber of Commerce. So when I found out I was going to be presenting this morning at the Comedy and Magic Club, I thought I would come up with some jokes. So I researched, I Googled jokes about AB5.
Yeah.
And what I found is AB5 is no joke. Which is funny, but because you can only laugh at this point in time. As Maureen indicated, I have a small law firm in Manhattan Beach, and we work with entrepreneurs, business owners, professional practice owners to help them set up their legal structures. So we take a holistic approach to business, so we actually focus on 5 main areas. We start at the foundation of the business, which is entity structures, LLCs, partnerships, that sort of thing. Then we focus a lot on trademarks for small business, because as people are starting and growing their business, they are coming up with a name for their business, a logo and what have you, and you want to make sure that when you buy the sign that's going to sit outside of your building, that no one else is going to send you a cease and desist letter and make you take it down. So that's part of what we do. We help with contracts, and so that is where AB5 really came into play with my clients, is people will come into my office and ask for an independent contractor contract. And over the past several years, I've been in the unfortunate position of telling them that their independent contractors are truly employees. So I say, congratulations, you're a California employer, welcome. And so we then really focus then at that point in time on employment programs, handbooks, policies and procedures, and all the joys of being a California employer. And then the 5th aspect of our practice involves real estate. We help real estate investors with their LLC structures for their commercial real estate, as well as commercial leases and buying and selling buildings and that sort of thing. So that's a little bit about my practice. Let's see. Hopefully this works. This is really fun, by the way, I have to say. I always say I've never met a microphone I didn't like. Some people, they say one of the biggest fears for people is speaking in public. That's never been my problem. Let's see. Hopefully it's gonna work. Is it working?
Okay, then I guess I'm your remote.
Ah, there we go. All right, I just go. Back to you, Mike. Okay, so my office is located in Manhattan Beach. If you've been driving down Sepulveda Boulevard, you might recognize our building. So we are conveniently located at 17th and Manhattan Beach, Sepulveda and Manhattan Beach. I am very, very local. I work with, I'd say virtually not all of my clients are South Bay, although I do work out of the area. I have clients who come to me from a lot of different locations. In my former life, I was exclusively a litigation attorney, so I was defending businesses in, like I say, virtually every courthouse in Southern California. And I'm proud to say that a firm that I left over 15 years ago still refers me their clients. So really nice. They happen to have a dental practice, and so I have dentists from all over the state of California. So I do work with clients outside of the area. I know that we had some people commute in this morning. Let's see if we can give an award for who came the longest distance. All right. Ma'am, where did you come from this morning? Yeah, we're going to make sure everyone's awake. See?
Tulare, California.
Tulare. So, wow, Tulare. That is really, really far. How many miles is that from here? 200 miles? Wow. Wow, all right, they may win. Who else is from here, from out of the South Bay area? All right, where are you from this morning?
Not as far as Studio City.
Studio City. It'll take you just as long to get to Studio City as to Larry. There you go, there's your joke.
It's over time.
Because the traffic is brutal. All right, so yeah, well, thank you for coming. As you know, AB5 is a statewide issue. Hopefully you are educated enough this morning that you will contact your assembly members and legislatures and let them know your opinion on AB5. I've been, like Mark mentioned when I spoke here this morning, I have a Google alert for AB5. So it's interesting to see what's happening. And unfortunately, AB5, as early as February, as recently as February, and I'll talk about it a little bit later on, is the model is being adopted at the federal level. So yay. The House of Representatives just recently passed a bill called the PRO Act, where now they're taking this debacle of AB5 that's destroyed small business in the state of California, and now they're actually contemplating taking it at a national level. So I think it's really important that we all unite and talk about how bad this is for business. What is AB5? So, you know, we hear about it so much, but what is it? So, it's sweeping legislation that basically says, if you have a business and you hire someone to perform services for your business, they are your employee, unless you can prove otherwise. And in today's environment, proving otherwise is becoming more and more difficult, right? As many of you, I'm sure, are finding in your own businesses. So, so basically, AB5 came about following a California Supreme Court case that came down in April of 2018 called Dynamax. It codified into law what's called the ABC test. Who has heard of the ABC test? All right, very good. Okay. So we are here to learn about what that is, because this is what has really been a stark contrast to the law of the land before April of 2018. I will say I've been practicing law now for over 20 years. The introduction is a little outdated. And started my law practice in 2007. So I've been working with small businesses over 10 years, particularly in the South Bay. And I will say that Dynamax was not a new concept, right? The idea that someone you hire for your business as an independent contractor could in fact be your employee is actually a concept that had been coming along for many years, even before Dynamax. But many industries, particularly the clients I work with, many of my clients, their custom and practice in their industry was to hire independent contractors. An example is, I represent a lot of fitness studios, yoga, Pilates, dance, that sort of thing. And so over the years, traditionally speaking, the instructors were independent contractors and actually prefer to be independent contractors, which is something that's really getting missed in the new legislation. Is many people want to be an independent contractor. They don't want to be an employee. And on the other hand, a small business doesn't want an employee because of all the costs, the expense, and all of that. But unfortunately, I tell my clients, it's not really your choice, right? It comes down to the government. The government, right? Over the years, over the past 10 years or so, I've really been seeing this presumption of employment becoming more and more pervasive. Starting with, I saw it started to come about mostly in an unemployment context, where I had a client who was a tutoring company almost 10 years ago, who hired their tutors as independent contractors. They had a tutor that worked for them part-time that made an unemployment claim, partial unemployment, saying that she was not getting enough hours. So you, as a small business, now get an unemployment claim and you're like, what? What is this, right? I don't have any employees, why would I be getting an unemployment claim? Well, guess what? The EDD says, oh yeah, no, and the unemployment insurance boards and all that say, no, these people are your employees. So this has been happening now for years. Yes.
Dan, could you state the other side? Like, I really want to understand, why did they make the law? Because there are obviously good reasons behind it, in trying to protect workers' rights, and there were abuses, I'm assuming. And can you just help us understand what that position is?
Sure. Are you my heckler? Good morning, nice to meet my heckler.
I just want to understand, because
No.
we've got to, hold both pieces.
Well, this is my presentation.
Right.
I'm just kidding. No, actually, I'm getting to that.
Okay.
Actually. Yeah, so, but I do want to say how it's impacted my clients, my law firm, my business, and I see it on a daily basis. That this is something that I work with small businesses who literally shut their doors, even before Dynamex. So what happened though is, Dynamex in 2018, the California Supreme Court had a case of delivery drivers that basically were hired as independent contractors, but California Supreme Court says now we have this new 3-part ABC test to determine who is an independent contractor. Okay, so what is the ABC test? All right, so here's the ABC test. It's a 3-part test. You must meet every single one of these 3 parts or else you have an employee, right? So historically, part A was not a problem with a lot of my clients who are hiring independent contractors. Essentially, part A is part of the traditional test that I'll talk about a little bit later called Borrello, the Borrello test. And the historical Borrello test was based on the right to control the manner and means by which the independent contractor performed the services they were hired to perform. So part A says that the worker is free from the control and direction of the hiring party. I'll skip to part C. Well, no, I won't. I'll go to part B. Part B is the part that really knocked a lot of people who were hired as independent contractors into an employment context. So part B is, so if you're reading on the internet and you hear about part B, this is part B. All right, so part B basically says that the independent contractor has to be performing services that are outside the usual course of the hiring entity's business. Okay, part B. So I use this as an example with my clients. It's the yoga, say a yoga studio. A yoga studio hiring a yoga instructor, right? So your yoga instructor, by definition, is part of the usual course of the business of the yoga studio. Your yoga studio hires a plumber. Your plumber is outside of the usual course of the business of the yoga studio. That is part B. Okay, and then part C says that then the worker must be engaged, customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed. So in my example, the plumber can't be your brother-in-law who's just coming in to do plumbing because he doesn't have his own independently established plumbing business, let's assume. So in order to meet all 3 parts, the worker has to have an independently established separate business performing the same services as they're performing under the contract with the hiring party. All right, so this is the ABC test. It's come to the point where there are very limited circumstances where a independent contractor relationship meets all 3 parts. So California Supreme Court kind of created this test, which threw everyone into a tailspin, right? It's like, what is the ABC test? So, to your point, the California legislature decided that they were going to come up with legislation to clean up the situation created by the Dynamex court. That is AB5. So this is the previous right to control test. So when the legislature came up with the with AB5, the attempt was to clean up what was created by the California Supreme Court. So I think let's assume, because we're not going to get political here, I'm not a true comedian, but whatever your politics are, let's assume that the California legislature had every best intention to clean up the situation created by the Dynamex court, to protect workers' rights, right? To protect workers from being taken advantage of, to give these workers the rights to unemployment, to benefits, because my clients are independent contractors, end up with a lot of independent contractors, and the next thing you know, they're giving health care benefits, which is an issue if you've got 50 or more full-time equivalent employees, which gets tricky. Anyway, but so that is the stated purpose of AB5, is to grant protections to workers to provide them with the benefits of employment, right? And so that is a good intention, and that is an intention that does, protect people who have historically been taken advantage of. An example is that I, in the past, have had a lot of clients in the construction industry. So I've had a lot of people construction companies who are taking advantage of people who were hiring them as an independent contractor, not giving them benefits of employment, and so on and so forth. So, and paying them under the table and all that. Of course, that also created a problem for my clients. My clients, I say, are people who like to make sure things are done the right way. And so my clients who were doing things the right way, who were hiring employees, giving them the benefits of employment, were then being undercut and going out of business because other people were not playing by the rules. That's called the underground economy, which is also a reason why the law has begun to favor and presume employment. In any event, so that's the background historically. So previous to the ABC test, there was a Borrello right to control test. And so this is important to know if you want to have a cohesive conversation over cocktails about this, is you want to know the ABC test is the California Supreme Court test, and the Borrello test is the historic right to control test, right? So, because under AB5 says that you must meet the three-part test, but there are certain situations where if you meet a whole bunch of other factors, then you get to apply the historic Borrello test. So just because you are able to, well, I'm jumping ahead, excuse me. Let me just kind of stick to my slides. Okay, so this is the right to control test. Essentially that goes back to what is now part A of the ABC test, is whether or not the hiring party has the right to control the manner and means by which the services are performed.
Can you give me an example of that?
Well, this is part of it too. So it kind of, by the other factors in Borrello, there were 11 factors. Some of them get broken down. These factors talk more about control, right? You control someone's manner. It's basically, you do not control the manner and means by which the contractor performs the services if you don't tell them the how, right? You tell them the where and you tell them the when, but it's the how. The how is where the independent contractor has the right and the ability, and that's what you're hiring them for. They have the specialized knowledge and training that you're hiring them for, so you shouldn't have to tell them how to perform the services. And if you are telling them how to perform the services, that is control. So Borrello also had a lot of other factors, many, many factors. And the thing about a Borrello is it's a weighing. To me, I've always thought it was like traditional scales of justice. It's truly a weighing of factors. No one factor is dispositive. No, you don't have to meet all of the factors. It's just kind of like you kind of say, well, we have this. We have, for example, an independent contractor who does not work at the location of the hiring party. They use their own equipment, right? They provide their own services. They pay their own expenses. They have their own insurance, that sort of thing. Note, always, 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 an important factor on who is truly an independent contractor, and this is what I always tell my clients, If you're gonna hire someone as an independent contractor, you wanna hire someone that has their own business entity, LLC or corporation. They have their own business license, which is a critical factor now. And they have, their own independently established business, right? And you always wanna have a written contract with that person that sets forth, number one, that they are in fact an independent contractor. That's one of the historic Borello factors, is that you actually have a written contract. And part of the written contract is that it meets the elements of Borello, because it would put the person being hired on notice that they're an independent contractor. However, many people say, well, I hired someone as an independent contractor, they had a contract. Isn't that enough? That is not enough. That's never been enough. The fact that you have a contract in and of itself does not make an independent contractor, yes.
Do they need to have a corporation with a business license?
In order to be safe, and remember, I work with people who are the hiring party, and I work with people who are the hired party. On behalf of the hiring party, I say, don't hire anyone who doesn't have their own LLC or corporation. You hire an individual, you are always at risk that that person can make a claim against you for employment.
Even if they have a business license?
Even if they have a business license. Now, on the part of the hired party, I tell my clients who are consultants or perform, outside services, it makes you now more marketable, particularly in light of AB5, that you can go to your clients and customers and say, I have my own LLC or corporation, I have my own business license, which is super easy to get, by the way, and then here's my contract that I'm giving to you. I'm going to be performing these services for you. So that, I tell the people who are being hired that makes them more marketable, because I tell my clients not to hire someone who doesn't have their own entity. So this is historic Borello. Right. All right, so under the new AB5 law, all workers are employees unless they're not. Now this is where it's getting tricky. So the legislature, in order to clean up the situation, said, all right, fine. The three-part test does not take into consideration certain professions that were historically independent contractors. So then they create a whole bunch of exemptions. Now, if you've read the text of the law, which I've read because that's my thing, it's very convoluted, I have to say, and it's not well drafted. But so if you have people like this, you've got licensed insurance brokers, physicians, surgeons, dentists, podiatrists, psychologists, or veterinarians. This is the historic professional services exemption, but they didn't go far enough. I've got clients who are physical therapists, dental hygienists, court reporters, people who were historically professionals and subject to being able to have their own independent profession that are not included in this exemption, and that's a big problem because I've got a client who's a sports medicine facility. They've got acupuncturists, nutritionists, physical therapists. They've got physical trainers. They have, and so for each person we have to say, do they fit under AB5? And unless they fit into these, technically no. Direct sales, salesperson, commercial fisherman, you can tell where the lobbies came from, right? And newspaper distributors and carriers. So even if someone that you're hiring falls within one of these exemptions, you still have to apply Borello. Like some people say, oh, okay, if they fit into this exemption, poof, they're out. You have an independent contractor. No, you still have to apply Borello, and that's really important to know. Okay, all of these people, right? If they meet each one of these, so professional services under AB5, in my mind, professional services was always physical therapists, acupuncturists, professional license. But under AB5, your professional services are marketing, which is a high-level, independently creative marketing, HR administrator, because you need one of them to figure out AB5. Travel agents, or that's my joke. I gotta laugh. Okay. Graphic design, grant writers, fine artists, IRS enrolled agents, Payment processing agents. These, under AB5, these are our new professional services providers. You will see if you, and I recommend having a Google alert for AB5, you'll see there's a lot of litigation going on. A lot of these categories of people, occupations, trades, what have you, have filed litigation to contest either the way that they're defined under AB5 or the impact that AB5 has had on them. Of course, we all have heard about the Ubers and the Lyfts and the Postmates and all of that. They filed litigation to halt the application of AB5 to their particular industry. Just as recently in the last week or so, their efforts have been rejected, and the court has refused to issue a permanent injunction prohibiting application of the law to them. So what that means is you can watch your ballots, because Uber and Lyft and those companies are joining together to put a ballot on to put it out to the vote of the people to say that the particular industry should not be subject to AB5. Okay? But at this point in time, the court has decided that it's refused to provide them with an exemption from AB5, essentially. So as you see, there are a lot of other different industries that are exempt, subject to certain limitations. And so the one that I wanted to use most for my clients is the business-to-business contracting relationship, which is one of these exemptions. So let me give you, just using that one as an example, let's see what you have to do to be able to fall within the business-to-business contracting exemption. Okay? Fill it. It's working a little too well. Okay, so in order to apply the business-to-business contracting exemption, remember this is only one of several exemptions, you must meet all of these factors. You see? So if you see you have to meet all, Borrello is away. Here, in order to get the privilege of falling within a contract-to-contract relationship, you need to meet all of these. Okay? The business service provider must be free from the control and direction of the hiring party. That is historically what we have. And for the most part, a lot of these factors are not too hard to meet, like I said. I mean, they can negotiate their own rates, they set their own hours and location of work. But where people are getting in trouble and where this exemption that should apply in most circumstances does not, is the second factor. The business services provider must provide services directly to the contracting business and not to the customers of the contracting business. This is where it gets tricky. So my tutoring company, 10 years ago, we got a revolutionary ruling even at the time that we argued for an exemption for their tutors, that their tutors, if they had specialized training, were in fact independent contractors. And we got an EDD determination that they were independent contractors 10 years ago. Very unlikely we'd get that result today. So they came back to me and they said, all right, let's analyze the relationship of our tutors under the new law. Unfortunately, the same tutors that were determined to be independent contractors by the EDD because they had specialized services, specialized training, for example, we had someone tutoring high-level math, had a math degree, right? They do not fall within this exemption anymore because my client, the tutoring company, would hire the tutor to provide tutoring services to the students that are the customers of the tutoring company. So, this does not apply. So, keep that in mind.
Yep.
Going back here, there are other alternatives. So, there's referral agencies. And I use a tutoring company as an example for a couple reasons. Number one, I just exhaustively went through the analysis. And number two, it's a really easy example to apply. So there's an exception for referral agencies who provide referral services for incorporated service providers. So if you read the text of the law, technically, the text of the law, like I said, is not well drafted, particularly from a legal perspective. It says that the service provider can be formed as a business entity, but it can be a business entity formed as a sole proprietor LLC corporation. So people are like, oh, well, I can be a sole proprietor and not have a business entity to provide these services, but no. A business entity is an LLC or a corporation, that's it. A sole proprietor is not a business entity. But an LLC or corporation can be taxed as a sole proprietor, you see? So do you need to be incorporated to be able to fall within this exemption? Again, incorporation is key. And incorporation in my mind is either forming an LLC or a corporation. And I'm always happy to tell you the differences. That's a whole other talk that I give, right? What's the difference between LLC and corporation? What's the best entity? How do you set them up? That sort of thing. That's another topic. I'm happy to talk to you about that. But so the referral agencies providing referral services for an incorporated service provider under the tutoring example. So if I've got Mr. Math Tutor, right, who has high-level math experience, who's being hired to perform the tutoring services, Mr. Math Services has to be Mr. Math Services LLC, Mr. Math Services Incorporated. And then my client, as the tutoring company, say they're ABC Tutoring Company, they would have to contract with Mr. Math Services LLC to provide these tutoring services, right? Under the referral agency exemption to AB5, Mr. Math, I can't remember the hell name I came up with. Anyway, Mr. Math Services LLC would have to go into the student's home and provide them with a card or hold himself out to be Mr. Math Services LLC. He would not be able to go into the house and say, I'm here on behalf of ABC Tutoring Services. If that makes sense. So the idea is that these referral agencies are providing referral services, helping someone to find customers for their own independently established business, which would be photography, tutoring, event planning, minor home repairs, moving services, home cleaning, errands, furniture assembly. So basically, you know, if you see there's a new company, it's called Tackle, I think. I saw the commercials, but basically think of Tackle as a referral agency for people who are providing furniture assembly services, right? So that's an example. So Tackle would list on their app people who are service providers who are providing furniture assembly services. Conceptually, and under the law, they should have their own LLC business license to be performing those services. If they're not, if they're a sole proprietor, the hiring party is always, always, always at risk of that individual coming back and making an employment claim when they're injured, or you let them go, and they're not happy about it, or what have you.
So you talk about the maid
House cleaning. So the same thing, house cleaning, home cleaning in this situation, would be you can have a referral agency that would provide home cleaning people, home cleaning cleaners, with access to customers who are looking for their services, right? So, so you could have the home repair referral agency or home cleaning referral agency. They're hiring individuals to provide cleaning services. The problem is that you do not want to be hiring an individual to provide home cleaning services that does not have their own LLC or corporation and their business license. How many times have I said it? What are the 3 things you need to have an independent contractor relationship in the state of California? Number 1. Number 2. Number 3.
incorporated.
Huh? Contract. Gotcha.
So
Those are the 3 things you need to really at least have a fair chance of arguing for an independent contractor relationship. Yes?
So I take it you're saying that if we were to hire a home contractor to do services for our office, the actual maid arriving would also need to have that status. So if we call the agency ABC Cleaning, and they send somebody to us, we are not guaranteed then that the person they're sending has an LLC or corporation or business license or whatever? So
No.
we need to make sure they also do who's coming?
Well, I think it's just, then it comes down to, as you run your business and as you hire people, I say, look, don't hire a referral agency to provide a house cleaner or to come clean your office, number one, that's a big problem. Or even a commercial cleaner to come clean your office, because there are a lot of other things I could bore you with called the joint employer doctrine, where basically, whose employee is that person? If that person shows up and they're sent to you by a referral agency, and by definition, if they meet all these factors, the person is not an employee of the referral agency, whose employee are they? If they're not incorporated, which actually technically they would have to be incorporated, then they may be your employee. So if you're gonna hire, if you need your office cleaned, hire a company that, an independently established, commercial cleaning company that is incorporated and has a business license and provides you with a contract for their services. It's just a matter of how you run your business to reduce your risk. Yes?
But how do you still know that the person they're sending
Yeah.
is an employee?
Yeah, I can see that.
Well, you would want to make sure that they provided you with a business card that shows that they are incorporated.
So you could actually still be in
Yeah,
trouble.
you still have your
Yes.
card,
You did
but
not know
for legal
who
purposes,
the
I'll have
person was they
to
sent.
put.
You
I'll
could,
have to
because
file
if they're an
DBA
individual
with
and they get
Development
injured
Services with
when
that
they're
name.
at your premises cleaning your location,
But otherwise, you have to
Right,
pay
that's the
$800
first 10
a
years
year
of my
for
career.
incorporating.
where I represented retail, restaurants, stores, homeowners, businesses with people who were injured, slip, trip, fall, whatever it may be, then yes, that person could arguably be determined to be your employee because
This is all bad.
it's called the
everything
joint
went
employer
through.
But
office.
then could
She
you go
signed
back
it.
to the
Yeah.
joint
Yeah.
employer
And that needs to-
call the
that's
home
what-
cleaning service agency?
Sure,
You need to find out.
absolutely.
So
So when that person sues you,
Like with you.
saying that they're your employee because they came to clean your office,
Right.
of course you would file a cross complaint against the cleaning company,
But that-
right, to say, hey, you provided this person.
Right.
But that's a situation you don't want to be in,
Nobody understands
because you don't want to be in a
this.
position of defending an employment claim. Let me see, yes,
On the trucking services, it says applications paid with the
what's that?
trucking services, it says
Application state, there was an application to, so you will read, there's a lot of litigation. The trucking services is the only industry that has succeeded in saying that AB5 does not apply to them under the concept of federal preemption, saying the federal laws preempt the state law with regard to their industry, because they're a federal motor carrier and they're all that. However, under the PRO Act, if the PRO Act gets passed, if it makes it through, then that could overturn that. But for now, trucking services is the only industry that AB5 does not apply to, and that they may still be independent contractors. I'm going to take some more questions. I'm almost done with my slides. So that's the business-to-business contracting exemption. Oh yeah, to make matters worse. So to make matters worse, this is what I talked about, is on February 6th of 2020, the PRO Act, which stands for Protecting the Right to Organize Act. Can we tell who's backing that?
The unions.
The unions. Again, whatever your politics are, this is now going to be the law of the land across the nation. And that is scary, especially seeing what a disaster we have in California. But in any event, so far it has passed through the House of Representatives. It's on its way to the Senate. Chuck Schumer from New York has already indicated that he will endorse it through the Senate. However, President Trump has put out, he's tweeted, that he's promised to veto the bill if it hits his desk. Let's hope it doesn't come to that. But in any event, I do think that it's just important to know kind of where the trends are and know that if people are, there have been a lot of additional bills submitted into the legislature to clarify further AB5 and even to repeal it. I will tell you, I don't see AB5 being repealed. It's not going to be repealed. So just deal with that. No, I'm just kidding. Okay, so as you as a business owner say, okay, fine, there's AB5. What is my risk? If I decide that I'm going to move forward, as an attorney, I always have to tell my client what the law is, and then it's up to my clients to make an educated business decision as to what they want to do in their business, right? So these are some of the risks of misclassification, because that's what we're talking about here. The argument is that you have misclassified someone as an independent contractor who is truly an employee. And so if you do that, there are penalties from you can get hit from a lot of different directions. So you have the California administrative agencies, the Department of Labor, the EDD, particularly the EDD, right? You've got unemployment, you've got unpaid employment taxes. So what do you think is the basis for this, right? The government wants their taxes, their unemployment taxes, their employment taxes. There's penalties of up to $10,000 for failure to have workers' compensation insurance. Keep in mind, if you have an employee, you are required to have workers' compensation insurance. If all the people you hire are independent contractors, by definition, you don't have workers' compensation insurance. So then you're going to get dinged for not having workers' compensation insurance. Civil penalties on a per employee basis between $5,000 per employee per pay period up to $25,000 per misclassified employee. Up to the $25,000 per employee comes from what's called willful misclassification, where you know the law and you say, screw it, I'm going to do it anyway. The government it will impose additional penalties. At the federal, you've got federal with your state taxes. You also have your federal taxes. A city attorney in cities like San Francisco, San Jose, Los Angeles, San Diego, with population of more than 750,000 people, the city attorney can look around and say, I'm just going to issue an injunction to stop your business. The biggest risk for my small business clients has always been that an individual who, usually, an individual, not an entity, will make a claim against the hiring party saying they're a misclassified employee. That's always been the risk. And with that comes unpaid wages, overtime, meal and rest breaks, because if you have an independent contractor, you're also not tracking their time. If you're not tracking their time, then, if they work more than 8 hours a day, more than 40 hours a week, then you've got overtime. And if you're not tracking their time, you don't know whether or not they've been, taking their breaks and all that kind of stuff. Unemployment, workers' comp, and discrimination, and so on. Just a whole lovely range of employment claims. Okay, so just a couple of things to note. Technically, the law was effective January 1, 2020. However, the law also states that it is a codification of existing law. And the question is, how far back does that go? Does it go back to April of 2018 with Dynamex? Maybe, maybe not. There have also been a slew of new lawsuits against people from businesses that have hired people as independent contractors, 2-3 years back, and people are coming back now saying they were misclassified. So that is a gray area. Technically, July 1, 2020 is a date for workers' compensation. I think that means basically you're supposed to have workers' comp for these people as of July, but I think just run out and talk to your broker now, get it today. If you have independent contractors, you need a written contract, and you need to report your independent contractors to the EDD. So this is a trick. So all our governmental agencies are talking to each other. So if you pay an independent contractor more than $600, you're supposed to file a form with the EDD, providing them with notice that you have paid an independent contractor more than $600. That form should be filed within 20 days of paying the independent contractor more than $600. The stated purpose for this rule has always been to find people who are delinquent in their child support. I think it's safe to say the true purpose of this rule is to ring the bell when you are hiring an independent contractor, say, here I am, I'm hiring independent contractors, and then the next thing you know, you have an EDD tax audit. Just saying. If you have people who are employees, right, if you get to that point, then you need an employee handbook, written policies and procedures, you need to provide meal and rest breaks, overtime, paid sick leave, all those sorts of things. So, I believe that's the end. Oh, free gift. It's an ebook I wrote, the top 5 legal mistakes small business owners make. If you text BizLaw to 26786, you can download the book. It's short. I wrote it. I think it's pretty good. I'm just saying. but that's a free gift. Okay, so Maureen, how am I on time, dear?
I think you're good.
I'm good? Okay, I'm happy to take questions. Okay, let's see, I'll go around the way. Yes, Mark.
So, not as an employer, but as an employee, I work for a medical billing company, and we just went through this sexual harassment prevention training
Oh, yes.
that's required.
Yes,
If an employer has more than 5 employees,
that's right.
they're required to provide this test
Yes,
during a time.
yes,
That's more than 5 employees.
that's right.
Let's say I do 2 productions a year. Each production has a cast of 5. But those are different employees. If I,
It's within the calendar year.
yeah, so
Yes.
if I hire five people for this production, I provide them with that training.
Within
And
30
then
days.
if I do another production and it's 5 totally new people, I have to provide them the training as well.
Right, so, so there are a lot, this is where it gets tricky, and let me just tell you, I'm happy to offer a 30-minute complimentary consultation for anybody who wants to speak with me directly about their particular situation. I'm an attorney, so I'm gonna give you my disclaimer. This is not legal advice. We don't know how to have an attorney-client